Okay.
Okay.
All right. So we're just going to go ahead and if you like, at any point you'd like to unmute yourself and ask a question, please do. And we're happy that you all are attending our webinar today on Pooled Special Needs Trust Administration. And I'm going to introduce Karen Konvicka. I'm Joanne Marcus, by the way. I'm the Executive Director of CCT, and Karen is our Director of Client Services and General Counsel.
And I'm going to start today with just a rundown of the fundamentals of pooled special needs trust, and public benefits. A pooled special needs trust, unlike a freestanding special needs trust, is a trust where a lot of different sub-accounts are mingled together for investment purposes. It allows our costs to be lower because we have one investment account for each one of our pools, but each individual has a sub-account that has their accounting, all of the ins and outs and payments and interest that would be attributed to their account is kept on their own sub-account. So that's the difference in the pooled. It's all of the accounts are pooled together for investments. And the special needs part is that these are primarily for people who are receiving public benefits or who have a disability that requires them or they would benefit from the management of their money. We have internally used the word advocate. That's a trusted family member or a friend, someone that's close to the beneficiary and can be the beneficiary, him or herself, that we interact with in terms of making payment requests and so forth. So we have two different pools at CCT. Most pooled trusts do. It's the two type of special needs trust that you've heard about that would be freestanding. A third party, which is someone else's money, a third party's money. So the grantor, usually we see a parent or a family member, but sometimes other third party individuals will leave money for the beneficiary and leave it to CCT to manage for them. That arrangement's revocable until the grantor dies. Once the grantor dies or the trust is funded, it becomes irrevocable. The third party trusts are not subject to any sort of Medicaid payback. We're going to get to what that means in a few minutes. But the third party is distinct from the first in that regard. And there's no age limit on a third party. Any individual can leave money to another individual of any age on the third party. The first party, by contrast, is created by a federal statute. The grantor can be the beneficiary, a guardian, the parent, grandparent, or the court. The funds are usually the individual's money, or are the individual's money, usually from a personal injury or workers' compensation, sometimes from a direct inheritance, Social Security back pay, or some other source of funds that the beneficiary had. They are always irrevocable. They are always subject to Medicaid payback. And there sometimes is an age limitation. 65 and older by statute can still create a pooled special needs trust, but in some states, 65 and older, when they make a transfer into the special needs trust, will incur a penalty. The third party trusts were not carved out by federal law like the first, but it is not a countable resource. And there's the PALMS reference. That's the Social Security Administration's Programs and Operations Manual reference to the third party. It must be for their sole benefit, and the trustee must have discretion. And if those things are met, then it is not a countable resource. The first party, however, was created in the 90s under it was a tax act that reconciled the budget. And there's two sites there that you may be familiar with. The one is a D4A trust, and that's the individual special needs trust. And then what a pooled trust is just two two paragraphs down in the federal statute, a D4C trust. And they're the other, the POMs and the regulations that set these up. So the difference between the standalone or individual special needs trust and the pooled trust, as I was alluding to in the beginning, is that when you draft a D4A trust or a testamentary trust under someone's estate plan, typically you're going to have a financial institution or a family member that wants to serve as trustee. Although most do, the beneficiaries aren't required to have a disability. For a pooled trust to accept beneficiaries, they must have a disability. And one of the disadvantages of that is oftentimes the trustee may not have good knowledge of some of the broader issues like tax filing, but also the specific issues that would relate to public benefits, SSI and Medicaid. The pooled trust, however, they must be by federal statute administered by a nonprofit organization. And the staff has expertise in public benefits, the SSI and Medicaid rules and regulations. So that is a real benefit to going with the pooled trust, because all of the pooled trust beneficiaries are disabled. They have the expertise in that area. But again, when you're doing estate planning, you look at this carefully and see if they're family members or financial institutions, or if a pooled trust would better fit your client's situation. And I wanted to go back just for a minute to make sure we're all sort of playing off the same sheet of music, if you will. And I call it my public benefits primer. The first thing is you have to be disabled in order to receive public benefits. In the Social Security Administration realm, you can read that yourself, but it says that you are disabled, you're unable to work, and it needs to be at least for 1 year, or it needs to be permanent. And it's similar for a minor, but it doesn't say anything about being able to work. Obviously, it says the seriously limits activities, and the same time limitation on that. So in contrast, that disability, I shouldn't say in contrast, that disability definition would go for SSI and for SSDI. So this side's starting with SSDI. So this is Social Security Disability Insurance. This is what comes out of your paycheck when you're paying the FICA and Medicare tax. It's going to the government. It's invested. If you become disabled and you've worked 40 quarters, then you're eligible to receive SSDI. The amount of that check that would come to you if you were disabled would be dependent on how much money you were making while you were working. So you get out what you pay in. In contrast to that, supplemental security income is what we have decided as a nation that if you are disabled and you are impoverished, that you are entitled to a certain amount of a minimum monthly income. So that's why it gets the name supplemental security income. It's $783 a month now. And that changes every year with the cost of living. It's intended to pay for the person's food and shelter. You can imagine how hard that would be to live off $783. So when people come into other money, that's why the special needs trust becomes so important to pay for their supplemental and special needs. The other requirement, in addition to making less than 133% of the federal poverty income, which would be under that 783, you cannot have any assets that are countable resources that are greater than $2,000. And I make the distinction about countable resources because you can't own a house, you can't own a car and some tangible personal property, but $2,000 is all you can have, say, in the bank. So a personal injury suit, a direct inheritance, those types of things would cause someone to lose their supplemental security income. And going hand in hand with these two programs is our federal health insurance programs. Medicare is the federal health insurance program that goes hand in hand with people who are disabled and receiving SSDI. It doesn't kick in for 24 months after you've begun receiving SSDI. And as everyone knows, it also is your Medicare is also the program that pays for your health insurance when you're 65 or older. And again, in contrast to that, Medicaid is what we have decided again as a nation that is going to be available to people who are disabled and also impoverished. So if you're receiving that SSI, Supplemental Security Income, you've been determined to be disabled and you're also determined to be impoverished, you will also get Medicaid. It's for the aged, blind, and disabled. Medicaid now becomes trickier because many states now have expanded Medicaid under the Affordable Care Act. And that's a little bit separate and apart because that is health insurance, and the health insurance that you enroll in, the premiums are paid for by the government if you are below a certain income level. And that's different than Medicaid that is paying actually for your health services if you're disabled. The distinction is important because expanded Medicaid doesn't have a resource requirement. Medicaid, again, matches with SSDI. You can't have more than $2,000 in countable resources to qualify. And so that's what public benefits primer and a little bit of background on special needs trust, pooled special needs trust. And I'm going to let Joanne tell us a little bit now about how a pooled special needs trust is set up with a trust administrator and how that operates.
So what are our responsibilities as trust administrators? Primarily, we're looking at accessing the beneficiary's trust for their benefit. And that's really important consideration. And going right along with that, for our beneficiaries, not all of them receive means-tested government benefits such as Medicaid and SSI, but our beneficiaries that do, it's our responsibility to be current on the rules. And that changes, you know, it's unpredictable. It is unpredictable. The palms change, and we have to be on top of it. And you know, clearly we have to keep excellent records because it's a huge responsibility that we have, and we want to keep accurate financial records that are accessible to our beneficiaries or their advocate or advocates. So that's something that is just to be expected. And then the nice thing about, you know, being a trust administrator is keeping the best interests of the beneficiary in mind. And that I really feel like we do make a significant difference in the quality of life of our beneficiaries. And it's extremely rewarding and helpful to us. And no, the other thing that we do, I don't do, thank God, you don't want me doing it, but the agency does, and the board of directors, we, in our case, in the case of CCT, we hire a fiduciary who actually takes on the role of managing and investing the funds for us. And on our board, we meet at a minimum of quarterly with the fiduciary and or the folks that manage and invest the funds, and once or more often, and once a year they come in and present to the full board. We have a finance and investment committee that has that expertise. So just a little bit about CCT. We've been around since 1990. It was founded by parents who wanted a nonprofit organization in this role. And I just think about them and I think about their vision, and it's quite remarkable to me that 30 years later, we have served 1,800 beneficiaries, and we are nationwide. So we have clients all over the country, including Tennessee. And as a nonprofit, we're proud to say that our fees are very reasonable. We will certainly accept the smaller accounts, and also the larger accounts. So, you know, it's not limited to just smaller accounts. We work very closely with attorneys and family members and financial planners in setting up the trust. And you know, our website is comprehensive. So that's a great place for information. Our staff is very professional and experienced, and you've already met Karen, and she's amazing, and she comes to CCT with many years of experience, including prior to working for CCT, 9 years on our board. So we also have what we've referred to as our online client account, where folks can access information about their trust. And remember when I was talking about accountability, and particularly financial accountability. So at any point in time, people can come to the website, access information about their trust online, up to date, what is the balance. They can actually make a disbursement request online and see that process and where it is up to the point that the check is mailed. So it's really quite amazing what technology can do today. And you know, I just kind of wanted to share a little bit about CCT, and I appreciate your willingness to learn about us. Just talking about fees and funding requirements in general amongst pooled trusts. And there's typically an enrollment fee, and all of this can vary. So it's, as you're doing your research and considering pooled special needs trust, that's something to definitely look into, or what are the fees, and not just the enrollment fee, but the ongoing fees. And that varies. And again, in general, pooled special needs trust, PSNTs, are going to be more affordable than a for-profit institution. And so I'm just kind of throwing that out, like a bank or an investment corporation. And then on the other advantage, I think, of a PSNT is that where our minimums are really small, and especially in the trust world, very, very small. So for example, CCT's minimum is $5,000, and for-profit or professional, I shouldn't say, but for-profit institutions are typically $350,000 to $500,000 minimum. And so that sometimes is definitely a reason why people turn to pooled special needs trusts. We're always asked, well, what can a trust pay for? And I just like to think of all the things that will enrich a beneficiary's quality of life. And we're definitely supportive, and you can see the list here. We are very conscientious about what is approved and what's dispersed from the trust. And we meet at least twice a week to discuss clients and what their needs might be for the trust, and making sure that we go through a process that ultimately either will lead to an approving the disbursement request or not. Now, some requests are fairly routine, like cell phone bills or cable bills, and it gets tricky around I don't know, you'd be surprised what our clients can think of, but I mean, it blows my mind. I've been doing this for 20 years. And after 20 years, you think I've heard of everything? That's not the case. But anyway, it's a lot of fun. I enjoy it. But so certainly vehicles and housing and the larger requests require group conversation. And we pay for care providers, and we certainly do pay for vacations too. It's not all business. We think our beneficiaries should be able to enjoy life. And again, it's all within reason and how much money is in the trust. And then also for third-party trusts, we ask for input from the grantor. You know, what is your vision for the trust? And also just a basic information about the beneficiary and when they set up the trust, and then as it changes over time until the trust becomes activated, because many of the third-party trusts are not funded until the death of the grantor or grantors. So we ask for input, we ask for a budget, and then we sit down and have a conversation. One of the things we definitely support and encourage prepaid burial and funeral expenses if they haven't been paid already, because once the beneficiary passes away, that becomes more complicated, particularly if the individual receives Medicaid and is a Medicaid payback trust. So is the third-party trust right for your client? What are some of the things you might want to ask yourself? I guess number one would be, does the beneficiary receive means-tested benefits, such as SSI or Medicaid? And if so, you want to make sure that whoever is administering the trust has knowledge about how not to jeopardize these benefits. And again, I've been doing this for 20 years, and fortunately we have contacts at the Medicaid or Social Security Administration offices that when we run into questions that we're not quite sure about, we can ask. So it gets really tricky at times. So you want to be confident that benefits are not going to be jeopardized. And then what about when you're thinking about, do we want a nonprofit? Do we want an institution? What are the objectives when the grantors are no longer here? Who are the individuals that could be named as the trustee? And how is that going to impact the relationship between the beneficiary and the trustee? And what happens when that trustee is no longer here? What's the backup plan? We like to say it's good to name, if you're naming an individual trustee, to also name a pooled special needs trust as a backup. Because one of the things we've seen is sometimes the named trustee really is surprised and not sure that they want to be in that role, or it creates conflict between family members, and they want to get out of that role. So having this as a backup plan can't hurt if the trustee passes away or really does not want to fulfill that role, or moves away, or just anything can happen.
I like to think of it as the trap door for the trustee that no longer wants to be trustee, to give them some sort of backup. So you're not looking for judicial intervention. Even saying that it could be the trustee is authorized to transfer the money to a pooled special needs trust. I've seen that work very smoothly, just to allow the trustee to get out of an untenable situation. Usually it's siblings, one sibling with another.
Mhm.
Yes, thank you, Karen. And then, just thinking about, does the beneficiary really need a trust administrator? What is the nature of their disability? And does that person, irregardless of whether they're getting means tested government benefits or some other type of benefit, but just solely, would that person benefit from having a trust administrator? And then as a first party trust right for your client, and that really, the first party trust, as Karen said, is when it's the beneficiary's own money, and looking at, again, benefits and how vulnerable that individual is to being taken advantage of, and who is available to administer those funds.
I think this is more of a summary,
Yep.
the slide.
So this kind of summarizes the benefits of a PSNT, and I'm not going to go through all of that. And now just talk about trust to able.
Right, we decided just to take one type of distribution and discuss that in a little bit more detail, just to give you a little flavor of some of the things that we do here. One of the problems that an individual who receives SSI may have is that actually I'm going to go forward a couple, is that if you pay for shelter expenses, whether that be rent or electric bill or any of the things that the POMs say are shelter expenses, if they're coming from a trust is considered a third party, and they will get a reduction in their SSI benefits. So sometimes that makes sense. Sometimes we approve that, and sometimes we do it. Sometimes we use something called the ABLE account. So when you make a distribution from a trust to an ABLE account, that is allowable under the POMs. And then from the ABLE account, for some reason that's really unknown to most people, that one of the qualified disability expenses is the shelter expenses. So if you can funnel the money through an ABLE account and then pay for the shelter expenses, you do not have a reduction in benefits. Why that is, I don't know. That's one of those odd things that Congress did. And so we now use the ABLE account to pay for those shelter expenses. Now I'm going to go back to, so what is this ABLE account? An ABLE account is a 529A plan. So it goes right there with the college savings plan, the 529 plan. And there was a family who lobbied Congress and they had a disabled child, and they said, well, this isn't really fair. Why can my able-bodied children have this savings? How come we can get tax benefits for that? Why are we allowed to do this, but our disabled child who's not going to go to four-year college, we don't have any savings for him? So Congress passed the ABLE account to take that into consideration. So you can put up to $15,000 a year in the ABLE account. There is a Medicaid payback in most states, just like the first party trust. If the assets in the ABLE account are not countable resources, up to $100,000. And the big kicker that is just the restriction that we have to live with is the person has to have been disabled before the age of 26. Doesn't mean the ABLE account needs to be set up before the age of 26, but the disability needs to have occurred before the age of 26 in order to utilize the ABLE account. You can have one, and there's different investment options and so forth. It has low fees, and people have a lot of autonomy. That was one of the issues with the ABLE account. They wanted to give the individuals a lot of autonomy. So that gives you a little bit of an overview of what the ABLE account is that we use. So in-kind support and maintenance, you get a reduction in benefits out of the trust because it's considered third party. You do not get a reduction in benefits when it's paid for out of an ABLE account. So we make the distributions to the trust, then payments for shelter come out of ABLE, and we've avoided that issue entirely. One caveat is that if the payments from the ABLE account are made directly to the beneficiary must spend them within the calendar month, or the funds will become a countable resource. And one of the other issues I wanted to highlight about pooled special needs trust that is different than a D4A trust. Both of them have the Medicaid payback that we've talked about earlier. So at the death of the beneficiary, whatever's left in the account, first we have to go to Medicaid in the state in which the beneficiary received Medicaid and ask them, how much did you pay for this beneficiary during the beneficiary's lifetime? And for the D4A and the D4C, it's expected that you're going to make that inquiry and make a repayment. Now, there is an exception to that, though. The PSNTs, the pooled special needs trusts, because we are managed by a nonprofit organization, because those trusts are managed by a nonprofit organization, the nonprofit organization which exists for the purpose of advancing the needs of disabled individuals, pooled special needs trust, then that nonprofit is allowed to keep the remainder under the federal policy. Now, Medicaid is a federal program that's implemented by the states. So the federal policy says that you can do it. No surprise, some states have different rules about whether or not they actually allow that. But what does that look like? So if we have a beneficiary who has $100,000 in the bank and in their subaccount, and their Medicaid repayment is $130,000. So the beneficiaries of that account, the successor beneficiaries, are never going to get any money. We're either going to pay the entire amount left in the subaccount to Medicaid to repay, or we can keep the remainder to help the needs of other disabled individuals. That's in contrast to other pooled special needs trusts, or not all, but some other pooled special needs trusts who keep the entire remainder either way. This is actually a really good graphic. I'm going to backtrack just for a minute. If the repayment is less than the remainder, so in that same scenario, it's $100,000, Medicaid is only owed $75,000. CCT would make the $75,000 payment to Medicaid, and the $25,000 would be paid to the successor beneficiaries. If the repayment is greater, which is the scenario I gave earlier, it's 130, then the beneficiaries, those successor beneficiaries, are never getting any money anyway. In those cases, CCT keeps the remainder. So those are the policies that are different amongst different pooled special needs trusts. Some pooled special needs trusts keep the remainder no matter what. They keep the remainder for third parties. They keep the remainder for first parties, even if the beneficiaries would have received money. And that's allowable under the federal statute. I was just saying, so some of them are different from state to state too. Some states say it's a sliding scale based on how long you've had the account. And if you've had the account for a very short period of time, then you can't retain the entire amount. The state wants, a certain percentage up to a certain amount. And some say just right across the board, you can never retain more than 50%. And again, that's because the states implement Medicaid. They implement it the way they want to, even though it's a federal statute. This is different than a state recovery. I just put that asterisk down there. If you know what a state recovery is, the medical assistance services departments can recover against an individual's estate, but this is different. This is Medicaid repayment that the trust administrator has an obligation to fulfill. Our remainder policy, in no instance do we retain the remainder at CCT in a third-party trust. Some do, some PSNTs do, but we do not. We just made that decision in the beginning a couple decades ago that we were not going to do that. And that's a distinguishing factor. You may want to look at that if you're considering a PSNT, because some do. In red down across the bottom, for both of these, I'm pointing out that you can't pay for funeral expenses after the beneficiary has died, whether it's third party or first party. So you want to make sure that, and we make a big deal with our beneficiaries to make sure that a funeral policy has been purchased and paid for prior to the beneficiary's death. So this is just a little graphic that explains the difference in special needs trust and pooled special needs trust. Again, the special needs trust, the D4A trust, must repay Medicaid in every situation, period. PSNTs are allowed to keep retain the remainder. We only do it if the beneficiary is not, but some do it in any situation because, again, it's a nonprofit organization that's going to receive the remainder.
And that's for first party trusts?
Yes.
Only?
Well, yes, because the third party trust doesn't have a Medicaid
payback.
It doesn't have the Medicaid payback. So for first party, that's the only time, again, that CCT does. But that's one of the distinguishing factors between us and some other pooled special needs trusts. And that is the end. So we just wanted to give you that opportunity to hear a little bit about pooled special needs trusts, to distinguish them from special needs trusts, talk about a unique situation using the ABLE account that we have started doing here at CCT. And then just to tell you a little bit about remainder policies. I know when I was in private practice, that was one of the things I always heard about pooled special needs trusts. Oh, they keep the remainder, they keep the remainder. Well, dig into it a little bit deeper, because not all pooled special needs trusts keep the remainder. And for instance, we only keep the remainder if the beneficiaries would never have received anything anyway due to the Medicaid repayment. Do you want to say anything else, Joanne?
I think Donna, did you have any questions, or is there anything that you would like clarification on?
Uh-oh. I can. I don't think so. It's something's wrong with the microphone.
Okay.
Do we have a chat box in here? I can hear that someone's trying to talk, but it's not coming through very well. Do we have a chat box?
Yeah. Oh, there you go. So everyone is unmuted or has the option to unmute themselves if you'd like to ask any questions. Now is a good time.
This is Barbara McGinnis. I just wanted to thank you ladies for such a great presentation. I've been looking at your website while you've been talking, and it does look like you offer comprehensive services that extend services I didn't realize were aware through your trust company. So I'm really grateful for this opportunity to get to know you better.
Great. Thank you very much, Barbara, and thank you all in Tennessee for the opportunity to talk to you.
We have brochures or packets of information, and as you mentioned, our website is comprehensive and user-friendly.
Yes, it is.
Okay.
Thank you.
All right. Thank you all.
All right. Thanks.
Have a good rest of the week.
Bye.
Bye.